our last roundtable here is called Federalism's Contribution to Economic Liberty, Catalyzing Technological Progress and Economic Growth. And here to introduce and moderate this panel is our brand new Judge Chad Riedler from the Sixth Circuit Court of Appeals.
Thank you, Stacy. Yes, my name is Chad Riedler. I'm a new judge on the Sixth Circuit. For those of you who have been looking for clerkships for the last 6 months and never saw my name, don't worry, it's not you. It's me. I just got confirmed, but I'll be sitting in Columbus, Ohio. We have 4 active judges there, and so hopefully I'll see many of you in the future when you're clerking in Columbus or on the Sixth Circuit. So it's a real privilege to be here, and it turns out I'm finishing my first week as a federal judge and here with the Federalist Society, so that's a great thing. I want to note that was purely coincidental, that my last week would conclude at a Federalist Society event. Having just gone through the confirmation process, I know there's a lot of misperceptions, and I don't want to further one. I suspect that many of the Democrats in the Senate think that all nominees, once confirmed in this administration, then go to a Federalist Society event. It's just coincidental, but I'm thrilled to be here and hope to be invited back. So we have a really terrific panel today, actually a roundtable, a virtual roundtable or theoretical roundtable. I think the hazing for the new judge is to give them the largest group to introduce, and so I'll be doing that in a minute. But I want to thank all the students who are here. Many people have thanked the law school, have thanked Grant and all the organizers, have thanked the Federalist Society, and I'd like to concur with all that. But congratulations to all of the students who are here. You've shown very early in your careers, in fact, before you're practicing lawyers, your commitment to learning, to studying legal issues, separation of powers, regulation, and it's terrific. I encourage you to stay involved throughout your careers, whatever your views are on the different issues. These programs are a great way to learn, to meet others who are interested in similar issues, and in 15 or 20 years, it'll be all of you who are up here leading the panels and presenting, and I look forward to seeing that. So our topic is Federalism's contribution to economic liberty. And our primary focus is going to be on the role that states play in advancing economic liberty, including a discussion of some practical examples here in Arizona and beyond. As I mentioned, we have a large group. Unfortunately, we're down one speaker. Professor Kimberly Robinson from the University of Richmond School of Law was supposed to join us. She unfortunately had a medical emergency in the family, and so we wish her and her family well. So I'm going to introduce the speakers, not in the order of speaking, but in alphabetical order. That seems objectively fair to me, and subjectively allows me to start with my fellow Ohioan, Jonathan Adler. Jonathan Adler teaches environmental, administrative, and constitutional law at Case Western Reserve University in Cleveland, where he is also the director of the Center for Business Law and Regulation. Professor Adler has authored 7 books, including a very fine book in 2016 about business and the Roberts Court. Many of you know Professor Adler. He's a much sought-after commentator in the media, a contributor to the Volokh conspiracy, and certainly no stranger to Federalist Society audiences where he speaks frequently on a wide range of topics. Dana Berliner, and maybe everyone should raise their hand since I'm not here in order. Dana Berliner is the Senior Vice President and Litigation Director for the Institute for Justice, a libertarian-based law firm dedicated to advancing civil liberties and freedom. During her over 2 decades of service at IJ, Ms. Berliner has litigated consequential property rights cases in courts around the country, including significant cases on takings law and eminent domain. Those cases include a significant victory in the Ohio Supreme Court, a decision that preserved property rights at the state level on the heels of the Supreme Court's Kelo decision. Ms. Berliner is also a frequent media commentator, as well as an author on publications regarding eminent domain. Clint Bolick. Clint Bolick is a justice on the Arizona Supreme Court, having been appointed to the court in 2016 by Governor Ducey, who's also our dinner speaker. The bench's gain was certainly the litigating bar's loss, as Justice Bolick had a prolific career as a practicing lawyer, defending the rights to private property and school choice in courtrooms around the country, including the United States Supreme Court. Justice Bolick played a leading role in the Supreme Court's landmark Zellman decision, which addressed the constitutionality of school vouchers, a case that I should note emanated from what state? You can probably guess. Ohio. There's a theme. Before his elevation to the Arizona Supreme Court, Justice Bullock was the Vice President for Litigation at the Goldwater Institute and was a co-founder of the Institute for Justice. Mark Brnovich. Mark Brnovich was inaugurated as Arizona's Attorney General in 2015. His ascension to the role of Arizona's Chief and Law Enforcement Officer is the latest example of General Brnovich's commitment to public service. He has served both as an Assistant U.S. Attorney and an Assistant State Attorney General, and he also was the Director of the Arizona Department of Gaming, and he too has also argued in the United States Supreme Court. Given our topic today, economic liberty, it's worth noting that few in the room are likely as appreciative of our American freedoms and liberties as is the Brnovich family. It was those protections that General Brnovich's mother pursued when she emigrated to the United States from Eastern Europe to escape communist society. I suspect General Brnovich has been to Ohio, but I couldn't find any way to work it in to the bio. I apologize.
Well, just so you know, Judge, not to interrupt your presentation, but when you work at DOJ or you've been in the military, you have a security clearance. And so when the FBI did my background check, they had asked me if I'd ever been to any communist countries, and I said no, but I did spend 2 weeks in Ohio. So. Sorry about that, Judge. Hopefully I never appear in front of you. Good lesson for the kids out there.
Next is Alan Ides. This is a tough job being a judge. I thought it'd be much easier. Alan Ides is a professor of law at Loyola Law School in Los Angeles, where he teaches civil procedure, constitutional law, and federal courts. He's also a graduate of the law school, disproving the old adage that you can't go home again. Professor Ides did take a brief respite from Southern California, where earlier in his career he taught in Virginia at Washington and Lee University School of Law. Professor Ides previously clerked for Justice Byron White and has also argued before the United States Supreme Court. And he's a prolific author, whether it be casebooks, law review articles, or high-profile amicus briefs. And, as it turns out, I just learned, his son and daughter-in-law are proud residents of Columbus, Ohio. So we're going to start the discussion with Professor Ides, who will kick off our roundtable with a theoretical discussion of economic liberty, including a review of Lochner versus New York, before we then turn to more practical applications with our other speakers.
Thank you so much. Thank you to Grant for inviting me and organizing this. And it's really a pleasure to be on this campus. This is a beautiful law school. I'm jealous. Of course, I have the ocean. You have the desert, I have the ocean. I'm going to kind of give a talk that's going to have an iceberg-like quality. Just going to hit the tip of the iceberg because there are a lot of little things that I need to say to pull this puzzle together. My topic is a little different than economic liberty as a product of federalism, but it's economic liberty as a product of, I would say, constitutionalism. And just a couple really fundamental things. The three separate key points I want to touch on. One is democracy and republicanism. The other is judicial review, and the third is the due process clause. And I think you'll see they're all closely related to one another. It's well known that the Constitution was built on a distrust of democracy. One of the motivating, if not the key motivating forces to the Federal Convention was a perception that democracy at the state level had gotten out of control. And so the principle of republicanism, which has nothing to do with the Republican Party, nor does democracy have anything to do with the Democratic Party, the principle of republicanism is built on, to a certain extent, a distrust of democracy and a belief, a deep belief, that government could be structured in a way to promote civic virtue. And hence we have the separation of powers within the three branches of the federal government, the separation between the states and the federal government, and a series of important checks and balances that are in part to check the people in power, but also to filter democracy through a system that is, in many ways, anti-democratic. Bicameralism, presentment, the composition of the Senate, I could go on. It's designed to filter democracy with the hope that virtue will rise to the top. Republican civic virtue. It also included, the body of the original Constitution also included specific limits on the state democratic impulse. The most notable and important one, just kind of tucked in there and rarely taught in con law anymore, is the Contracts Clause. This was one of the key motivators for the Federal Convention, the fact that states were forgiving debts that had been incurred during the Revolutionary War. And the Contract Clause specifically limits the state's democratic authority to do that. On the other side of republicanism, our intention with it is this principle of democracy. Democracy was reflected more in the anti-Federalist papers than in the Federalist papers. In fact, this is maybe a terrible thing to say, but I always thought the Federalist Society should have been the Anti-Federalist Society, because that's really the states' rights society. And so democracy was reflected in the Anti-Federalist papers, and it's also reflected in certain essential founding or historical documents. The Declaration of Independence is much more democratically themed than the Constitution. It comes later, but Lincoln's Gettysburg Address is distinctly democratic. I take as my definition of democracy, of the people, by the people, and for the people. And I think Lincoln captures that well. The Bill of Rights is a reflection of a democratic impulse. The Bill of Rights is a reaction to what the Anti-Federalists saw as the excessive amount of republicanism in the Constitution. They wanted a democratic guarantee. And if you go through the Bill of Rights, most of its parts are directed toward rights of the people that would be essential for an effective democracy. Speech, and if you accept Justice Scalia's interpretation of the Second Amendment is a people's right, the right of the people to be free from unreasonable searches and seizures, the right to due process of law. So I see the Constitution, the original Constitution, as tending toward anti-democratic, very Republican, in good ways, too. And I see the Bill of Rights as a strong democratic response to that. So that takes me to judicial review. And the typical approach to judicial review is to cite Alexander Bickle's statement that judicial review is a deviant institution in the American democracy. I say no. Judicial review is a Republican part of the American democracy, if you will. It is meant to ensure that the structure of government is adhered to, that Congress operates within and only within its enumerated powers, that the branches operate in the fashion that it's designed to operate in the Chadha case, bicameralism. So it's not a deviant institution. It is in part a Republican institution, but I also think the judiciary is potentially the most democratic institution. It's true. Federal judges like Judge Riedler they are appointed for life, they're not elected, but that doesn't necessarily make the institution an undemocratic or anti-democratic institution. If the role of judges, in large part, is the enforcement of rights, then they play a role in the enforcement of the Bill of Rights, the Civil Rights Amendments, post-Civil War, and those rights are democratic rights. And I'm not talking about just one person, one vote, or gerrymandering. I'm talking about all enforcements of liberty and equality interests are democratic. And they are not necessarily anti-democratic because perhaps a legislative judgment is being overturned, because I defy you to establish that legislative judgments are themselves universally democratic. They're Republican, frequently. So not a deviant institution. judicial review is not just a device of republicanism designed to create the structure. It's in between. It's the best of both worlds. It is Republican in nature, but potentially democratic in operation. And that brings me to the Due Process Clause. The Due Process Clause can be traced directly from Magna Carta's law of the land principle, which was eventually, after a couple of centuries, evolved into the phrase due process of law. And the law of the land principle is a principle that objects to the arbitrary application of law. And a law can be arbitrary in application and arbitrary in its substantive content. So due process was a promise that the laws would not be arbitrary. And I think that translates into both procedural due process, right to notice and a hearing. The law should be established before it's enforced, but also to the substantive content of the law. So I have a slightly different view of Lochner and the more modern cases such as Ferguson versus Scrupa, Williams versus Lee Optical, and the one I'm going to talk about very briefly, New Orleans versus Dukes. I think Lochner is right in theory. I think Lochner was right in theory. After all, what did the court say in that case? Economic legislation must rest upon reasonable grounds. I think that's got to be right. Because if it doesn't rest on reasonable grounds, by which I mean some fact-premised grounds, then it is arbitrary. And so when somebody refers to the Lochner era, it makes me a little nervous because you're supposed to have a knee-jerk reaction to, oh, Lochner, that was bad, judicial activism, anti-democratic, so on and so forth. But I think in theory it was right. I think in fact, Lochner was wrong. And the reason I think Lochner is wrong is found in Justice Harlan's dissent, where he, very detailed manner, goes over the available science at that time that established the proposition that the job of being a baker was a particularly unhealthful and dangerous one. The majority went on, it's kind of imagined set of facts that it said, well, everyone knows being a baker is not that tough of a job. And you read Harlan's opinion and say, well, wait. The available material to the legislature would lead or could lead a reasonable legislator to say, this is a reasonable protection of bakers. They need our help in this context. And so if you read the opinions, the two opinions, the contrast is kind of remarkable. The majority saying, hey, the law just needs to rely on some reasonable grounds, and then said, but common sense tells us to the contrary in this case. Well, I don't think judges should be just applying their common sense. They should have common sense, of course. But they shouldn't just be applying their common sense. They should be deferring to the legislative judgment, but the legislative judgment should be built upon something. So often placed in contrast to Lochner are cases like City of New Orleans versus Dukes, which is kind of a combination due process equal protection case. For those not familiar with that case, the City of New Orleans passed an ordinance that basically gave one hot dog vendor, if you've ever been on Bourbon Street, you've seen it, Lucky Dogs, the right to operate a hot dog stand on Bourbon Street and in the French Quarter, and all other companies that were operating similar stands were banned from the French Quarter. And the law was designed and written in such a way is that it excluded everyone except Lucky Dogs, without saying Lucky Dogs. So it was designed for the benefit of Lucky Dogs. An individual who'd been selling had a concession that was operating food stands in the French Quarter, filed a lawsuit challenging it. The district court, applying the anti-Lochner approach, said, rational basis, the city can do whatever it wants in this area. The Fifth Circuit, on a very liberal panel, as a matter of fact, applied a form of economic due process and concluded that the peculiarity of the statute was enough to raise a suspicion that this was in general, a rent-seeking statute designed for the benefit of one group to give them a monopoly. and it struck it down. And it's a very carefully reasoned opinion. It recognizes that usually we defer to the legislative judgment, both at the national level, the state level, and the local level, but there is enough here to trigger our suspicion. And I note that one of the judges in the case, Judge Minor Wisdom, was a resident of New Orleans and was familiar with the way the New Orleans City Council operated. So the judges were suspicious and they struck it down. The Supreme Court's response was wrong in theory and wrong in fact. The Supreme Court reversed, and it didn't adopt the Lochner model some reasonable basis. It didn't even adopt some rational basis. It was some conceivable rational basis. So the standard the court adopts in Dukes is not a standard based on the facts. It's a standard based on anything we can conceive of. And so based on, I think they got the facts wrong too, because the facts were imagined facts. They imagined that the city council might have thought this, and if they did think that, that would be fine. So I really find that troubling, because judges, Article 3 judges in particular, are supposed to apply the law to the facts, not to an imagined set of facts. So I think Dukes is wrong in theory and wrong in fact. So what I feel, what the message I give for economic due process is, I think there is a role for the due process clause. I don't think rational basis should be based on some conceivable set of facts. It is a pro-democratic impulse that would lead a court to carefully examine the sometimes corrupted democratic practices that lead to laws that offer rent-seeking or are irrational in terms of the legitimate interests of a city council, a state legislature, or the federal government. I don't think courts should be actively involved in striking down statutes. I think they should defer to the judgment of the legislative branch, but there should be a judgment of the legislative branch to examine. So not a conceived set of facts, but a real set of facts. So Lochner's standard, but then apply it with deference and careful judgment. Thank you.
So next we'll turn to Justice Bullock, who's going to offer some responses to Professor Ides, and then we'll start to turn our discussion to practical applications of economic liberty, starting with some developments here in our host state of Arizona.
Thank you. It's great to have everyone here in Arizona. Judge, welcome. I love the time that I spent in Ohio, though I have to say that preparing for today's remarks outside was something I probably couldn't do in Ohio. And by the way, for those of you who are not from Arizona, the weather is actually like this all year round. This notion of an ungodly hot summer is actually a marketing ploy to keep Californians from moving here. So
It worked.
don't believe it. You can't have as long and close a relationship with the Federalist Society as I have been lucky enough to have without being a complete and total nerd. And part of my credentials in that regard is that from my earliest time as a lawyer, I vowed that I would do everything that I possibly could to overturn the slaughterhouse cases. And 2 years after I graduated from law school, 35 years ago today, and I just realized as I was rereading this amazing debate that it is the 35th anniversary of this debate, the Cato Institute hosted a conference very much like this one, except much, much smaller than this one, because the interest in economic liberty had not really gotten significant. And the centerpiece of that conference was a wonderful debate between a then member of the DC Circuit Court of Appeals and a young Chicago law professor. And they debated the topic of the judicial protection of economic liberty. And the DC Circuit judge argued that we should not provide judicial protection for economic liberty, mainly because the substantive due process theory itself was an abomination and should not be extended to protect economic liberty. The young law professor, I believe, won that debate, as he has won every debate that I have ever seen him engage in the 35 years since then. But it was the DC Circuit judge who actually said some things that inspired me, that motivated me in my career. He finished his debate with the following words, and he was not unfriendly at all to economic liberty, quite the contrary. He said, "The task of creating what I might call a constitutional ethos of economic liberty is no easy one, but it is the first task." That DC Circuit judge, 2 years later, became Associate Justice Antonin Scalia, and the young University of Chicago law professor became, of course, the legendary Richard Epstein, who, of course, began our conference by repeating the message that I think has found tremendous substance in the law. And I think that 35 years later, that effort of rebuilding or building the judicial ethos of economic liberty is really coming to fruition. For me, it was a call to arms. For my part, 4 years after that debate, I wrote my first book, a book called Changing Course: Civil Rights at the Crossroads, in which, among other things, I called for Slaughterhouse to be overturned. I would like to say that that book sold thousands of copies and became a New York Times bestseller. However, were I to say that, the Attorney General would probably bring charges of fraud against me because hardly any copies were published and sold and read. However, perhaps the triumph of that book, or one feature of that book, was one of the people who blurbed that book on the back cover. At that time, I was a DC lawyer. I didn't know very many people, so I was looking for book endorsements, and I said, you know what? I'll ask my boss. I was working at the EEOC at the time, and my boss and I had bonded over two things: our love for Southern food and our disdain for, of all things, the slaughterhouse cases. And at the time, we were probably like two of maybe 8 people in the entire United States who had ever even really heard about this. In fact, in my bar review course, they told me the only thing you need to know about the Privileges or Immunities Clause is that it is never the right answer to a bar exam question. And that really was right, but my boss agreed to write a blurb for the book and endorse the book. And not too many years later, he too followed in the footsteps of Justice Antonin Scalia and became Associate Justice Clarence Thomas. Now, there's a message in this. If you speak and write about economic liberty, chances are you too will become a member of the United States Supreme Court. So good thing you're at this conference. My own path in this area in terms of contributing to the building of the constitutional ethos of economic liberty took two forms: litigation and legislation. And in fact, both of those were launched in 1988. In 1988, I won my first major case in the district court, federal district court for the District of Columbia, in a case called Brown versus Barry, in which the district court became the first federal court in 50 years to invalidate economic legislation. In this case, a ban on street corner shoe shine stands under the civil rights protections of the federal Constitution. And that case, the little guy challenging government regulation, challenging regulations on entry into professions and businesses, became the prototype for much incredible economic liberty litigation that has been done over the years by groups like the Institute for Justice, the Goldwater Institute, and Pacific Legal Foundation. And that was the year that started. That same year, I wrote another book called Transformation, which may have sold even less copies than Changing Course. But in that, I proposed an Economic Liberty Act that would overturn the slaughterhouse cases legislatively, and instead of placing the burden on the plaintiff in challenging economic regulations, it would place the burden on the government to justify those regulations. After that, absolutely nothing happened on the legislative front. This idea of an Economic Liberty Act gathered dust. However, though I had proposed this as federal legislation, a group that many of you are familiar with, the American Legislative Exchange Council, made it model state legislation. And I'm happy to say that 20 years after the idea was proposed, it became law right here in Arizona. And like so many good laws, this is a law that is so crisp, so simple, that it is quite short. For those of you who are interested in taking a look at this, it's Arizona Revised Statutes, Section 41-1093.03, and it reads in its entirety that any individual may file an action in a court of general jurisdiction to challenge an occupational regulation. To prevail in an action challenging the occupational regulation, the court must find by a preponderance of the evidence that the challenged occupational regulation on its face or in its effect burdens the entry into or participation in an occupation, trade, or profession, and that this state has failed to prove by a preponderance of the evidence that the challenged occupational regulation is demonstrated to be necessary to specifically fulfill a public health, safety, or welfare concern. In one fell swoop, within the corners of this state, the slaughterhouse cases essentially have been overturned legislatively. In addition to that, there has been a tremendous amount of litigation under state constitutions, and of course, the theme of this conference is federalism and economic liberty. And so much of the action is happening at the state levels in state courts because we are free to interpret our constitutions more broadly, not less broadly, but more broadly in their protection of individual rights than the federal Constitution is interpreted. In fact, one of the judge's colleagues, my old buddy Jeff Sutton, who is on the Sixth Circuit, wrote a phenomenal book on state constitutions that really talks about some of the tremendous potential here. And one case is an exemplar for this. It's another old friend of mine who was recently demoted from the Texas Supreme Court to the Fifth Circuit Court of Appeals. He's known to many of you. His name is Don Willett. And I have to say, I have huge jurisprudential envy over this decision. Some of you are familiar with it. It's a case called Patel versus Texas Department of Licensing and Regulation. And this struck down, under the Texas Constitution, regulations of eyebrow threading. To this day, I have no idea what eyebrow threading is. If your eyebrows are threaded, would you come up to me during the conference? Because I need to finally figure this out. But in any event, it was sufficient for the Texas Supreme Court to strike this down. A passage from the Constitution, I think, really summarizes the role that state constitutions can play in this. He says, today's case arises under the Texas Constitution, over which we have final interpretive authority, and nothing in its 60,000 plus words requires judges to turn a blind eye to transparent rent seeking. I have yet to be able to rate transparent rent seeking in any of my decisions. I am really jealous. that bends government power to private gain, thus robbing people of their innate right antecedent to government to earn an honest living. Indeed, even if the Texas Due Course of Law Clause mirrored perfectly the federal Due Process Clause, that in no way binds Texas courts to cut and paste federal rational basis jurisprudence that long postdates enactment of our own constitutional provision, one more inclined to freedom. The possibilities are incredible, and the last 35 years dating back to the incredible Epstein-Scalia debate, which is still, by the way, available from the Cato Institute and still as resonant as it was when that debate took place. The work that has been done to restore the constitutional ethos of economic liberty has been amazing. I hope that someone in this room, maybe many people in this room, will be the ones who will finally restore the great promise of the 14th Amendment, a core of which was to protect one of our most fundamental civil rights, the right to economic liberty. I think we're in a good place. At least two justices of the U.S. Supreme Court have indicated that they would vote to overturn the slaughterhouse cases. But however it is done, this has been, since the slaughterhouse cases, this has been a dark mark on our constitutional jurisprudence, and one that I believe is ripe for creative litigation, creative legislation, and for tremendous change. In that regard, I close with the only two words of Latin that I think are really, really important: carpe diem. Thank you very much.
So now we're here from Ms. Berliner. She's going to give us some examples of other technological advancements at the state law level, and I think also pick up on the theme of state constitutional law and its role in preserving economic liberty.
Absolutely. So a lot of people have referred, and Clint just talked about the Patel case. It is definitely true that much of the action right now on economic liberty is in state constitutions, state judicial decisions, and state legislation. And that's something that we do a lot at the Institute for Justice. I'm going to talk about some of those. I have to respond to Professor Hills, even though he isn't here, who said very strongly that we should pursue only state constitutional litigation because there's no federal protection whatsoever for economic liberty. I don't agree with that at all, but there is a lot to be done in the states. And so first, it's important to realize state constitutional texts are not little copies of the U.S. Constitution. Some of them were written even before the U.S. Constitution. Some were written in the 1970s. They're all in between. Some are based on the Northwest Ordinance. Some have due course of law provisions. Some have anti-monopoly clauses, some have anti-gift clauses, some have anti-favoritism clauses. They have all kinds of stuff in them that is not in the U.S. Constitution. And Stephen Calabresi is someone who writes about that and catalogs different kinds of state constitutional provisions in his work. So there are all of those. In addition, there's most states have at least two, often something like 4 different lines of interpretation of the rational basis test or the equivalent thereof. So most states are a total mess on this. There will be one line of cases that strictly follows federal law under the state constitution. There will be one line of cases that uses perhaps the real and substantial test, which was a big test that a lot of states used in the middle of the 1900s. And that, like you might think, involves real evidence, substantial relationship. There are other states that have a line of reasonable relationship, which doesn't tend to be rational basis. And then there are people that have things in between. And as I said, most states just have
a bunch of these going on, complicated tests, maybe with multiple factors. In Texas, the way that we got Supreme Court review was to say, you've got 3 lines of cases that are all in conflict with each other and never cite each other. You should resolve that. And they did. But that's true of like virtually every state court right now, which means there's a huge opportunity to get economic liberty jurisprudence and different tests. And I do want to talk for a second about what the Patel test was, because it's not the federal test. First of all, you look at legitimate government interest, but it's not conceivable government interest. It's what was the government interest. Then you look at actual facts, to real facts in the real world, to determine if there is a relationship between those facts and the actual purpose of the statute. And then, even if there's a real relationship, you look to see whether the law is so oppressive or burdensome to the individual that it does not justify the achievement of the supposed public purpose that it achieves. So, completely different test. It's a 3-part test. I don't think any other state has that exact formulation, but they could. And so we're litigating in a bunch of different state high courts. We've got one at the Pennsylvania Supreme Court. They're actually usually more protective than some of the other states. We've got one at the Illinois Supreme Court. They are usually not more protective of economic liberty, but you don't know. Both of those are really about the question of whether economic protectionism is a legitimate government interest, something that has largely not been decided by almost any state court. So it's a wide open area. So that's all. Oh, I'm sorry, I have to tell you about one other, which is in South Carolina, we are essentially bringing Lee optical and saying, don't follow the US Constitution on this. Go with your own Constitution, and under the South Carolina Constitution, Lee optical, the plaintiffs would have won. So that's a fun case. I can't wait to see what happens with that one. That's what's going on in state constitutional law, and I also just want to point out that there's a lot going on right now in state statutes. For one thing, we've talked a lot about licensing laws here. Licensing is extremely varied across states. We did a study called License to Work of 102 lower income occupations. Of those, less than 10 are licensed in every state, and there's only 23 that are even licensed in 40 states. So for almost everything, there's at least a few states that don't license it. And there's wide variation in the burdens. So in almost every state, there's no licensing of residential landscapers, except in 4 states where it takes you 4 years to get the license. And this difference is something that states can use to determine whether they actually need the licenses that they are imposing and whether they need them at that level of burden. 2 states have now passed laws to do exactly that. Nebraska and Ohio have passed the broadest economic liberty legislation in recent years. And both of them are doing what's called sunset review, where on a rolling basis they review all licensing laws and determine whether the regulation is truly necessary and the least restrictive way of achieving whatever health and safety purpose it has. Ohio also has passed sunrise review, which means every time somebody proposes a whole new set of regulations, they will look to see whether that is in fact necessary. And that's important because there is always pressure to have new licensing regulations. Like right now, there are nationwide lobbying efforts on music therapy, interior design, and lactation consultants to make licensing of those much more restrictive and make it hard to get into those occupations for everyone who is not already in those occupations, because they'll get to stay in the occupations, of course. So those are the broadest things that have passed. It doesn't always work, and that's something that was talked about a lot in the earlier panel today. Florida has been trying to repeal licenses for 12 occupations, including things like auctioneer and interior design and some other like really minor things, and they cannot get it passed. They have already failed 3 years in a row to get it passed. They're trying again this year, we'll see. But it is very hard to get repeals passed because of the intense pressure from the people who are benefiting from the laws. One area there has been significant improvement, which we heard about in the panel in the middle of the day today, is that a lot of states, 18 states in the last 4 years, have reduced the barriers for ex-offenders to get licenses in different occupations. And in some states, there's just an opportunity to find out whether you could get a license before you go through the entire educational requirement to do so. In other states, they've said that the crime has to be related to the occupation before you can prohibit people from going into it. That would seem kind of obvious, but it isn't. We have a case in Pennsylvania where a woman, I think, had an assault conviction 20 years ago as part of a domestic dispute, and she was not being allowed to become an esthetician. Absolutely no relationship, and no claim even of a relationship, but she was prohibited from working. So all of that is going on, and that's a really interesting development. I think there's significant legislative pressure to make that change, probably more even than licensing change overall, but I'm hoping it bleeds over into licensing change too. One other area that there's been a lot of development is in food freedom and the ability of people to make food in their homes and then sell it. 3 states, Wyoming, North Dakota, and Utah, have passed really sweeping reforms that basically just say, if it's not meat, you can make it in your home, you can sell it to people. And that includes perishable things, things with milk. Since those laws have gone into effect, and the first one was 4 years ago, there has not been one single report of a foodborne illness from one of these home-prepared foods. And this shows like all of these incredible barriers that are in place for food preparation are probably not necessary. They could do with a whole lot less and achieve, to the extent they're achieving any result, achieve that result. So that change has been made, and a bunch of states also have made it possible at least to sell shelf-safe foods like cookies and cakes directly from your home. And all of these things have a huge impact, of course, on people who can finally work, and also, I think, are going to show, I hope, the more regulated states will show them, hey, this other state is doing something totally different, and there have been absolutely no adverse consequences from it. I would love for that to spread as a legislative matter, and that's something that we're working on and that I'm hopeful about. At the same time, though, you can't get away from the need for actual judicial, constitutional decisions protecting economic liberty at the state level, at the federal level, because it is the only way that these rights are truly guaranteed and not subject to repeal. Thank you.
Great, so next we'll hear from Professor Adler. I was going to follow up, I think, on some of the comments that we've heard already, and then potentially address the issue of marijuana regulation and deregulation, and explain how that fits into our broader discussion of economic liberty.
Great. Well, thank you. It's a pleasure to be here. Pleasure to be in Arizona. Admittedly, better weather than back home in Ohio. And it's a distinct pleasure to be at Student Symposium, which has always been one of my favorite conferences, going back to the first one I attended in 1991 as an undergrad when it was at Yale, and I believe when Dana was at the law school. And it's great to be here on this panel with so many old friends, including my former attorney, who's now a judge in the Sixth Circuit. And I should just note, it's great to see such representation of the Sixth Circuit. 3 of your panels this weekend have been moderated by Sixth Circuit judges, I think providing some of the evidence for why many of us now believe that the Sixth Circuit is probably the best circuit in the country. And we're very proud of it. What I want to talk about very briefly is the system and structure of federalism and how that structure, the constitutional design, and the insights behind it can be understood as a structure that is particularly conducive to the promotion of economic liberty, and in particular, if, as many of us believe, economic liberty is essential to human flourishing, and that allowing for and expanding economic liberty provides for greater human flourishing, then a federalist structure like the one we have is an important part of demonstrating that fact and providing the creation and discovery of knowledge that allows economic liberty to proliferate. And this is something that Dana, in her remarks, I think hinted at when she talked about how the experience of reforms in some states hopefully can and should lead to reforms in others. And if time permitting, I'll say a tiny bit about how, unfortunately, the federal government and federal law, particularly when not constrained to its constitutional bounds, can get in the way. As we all know, our constitutional system creates a structure of dual sovereignty, a system in which both the federal government and the state governments are sources of power. Under our Constitution, the federal government has limited and enumerated powers designed to allow the federal government to address those issues and concerns in which there is a distinct federal interest or distinct comparative advantage of addressing matters at the federal level. And that all other powers are reserved to the states or to the people, that states may operate within the scope of the legitimate police power to deal with a wide range of matters that do not have a nexus to federal concerns and therefore do not need to be addressed in Washington, D.C. And I should note that I'm only talking about the federal government and state governments because for constitutional purposes, that's the relevant distinction insofar as states in turn delegate or authorize the exercise of power. At the local level, that's a matter of state law governed either by state constitutions or state statutes. And for constitutional purposes, those actions of local governments are treated as if they are actions of the states. The structure that we have, provided that federal power is in fact limited, places states in a position where they have to compete with one another for the allegiance of their citizens, for taxpayers, for investors. States are in a position where if they can create the set of laws, enact and enforce the set of laws that provides an institutional environment in which individuals may prosper and flourish in communities that are consistent with their values, they benefit from that. If they overregulate, if they overtax, if they overpunish, overrestrict individuals and groups, then those folks can leave. And just for you, those of you that are here in Arizona, hopefully when they leave, they've learned the lesson not to allow their new state to replicate the policies that they're fleeing from. As I understand, some of the Californians who moved to Arizona don't always appear to have learned that lesson and seem to want to replicate the things that caused them to leave California here. Another aspect of this system, though, that I think is not always appreciated is the fact that this competitive structure allows for the generation and discovery of information just like competitive economic markets do. We can talk about the importance of economic liberty in very broad terms, but a lot of times the devil's in the details. If you're going to regulate a particular industry, it's not simply a binary choice. Do we regulate the industry or do we not? It may matter how that industry is regulated, how it is taxed, whether things are enforced criminally or civilly, how enforcement is addressed, what sorts of presumptions are made about what sorts of activity are lawful or not, and so on. And having different jurisdictions try different things allows us to learn a lot about how can we protect those matters that need to be protected, but do so in a way that is most consistent with economic productivity and the other things that are essential for human flourishing. This is why we've often referred to our states as laboratories, as democracies, because in many real respects, we want them and need them to be engaging in experiments, to adopt policies that may succeed, but also to adopt policies that may fail, because just as a business failing is important information and generates knowledge for us in economic markets, policies failing generates important information for us in the context of political markets. And so the Federalist structure allows us to see the results of such experiments, allows individuals in state capitals to see what's happening in their neighbors, and there's an increasing amount of empirical literature that shows that when states discover a good way of solving a problem, a way that's not particularly burdensome or pernicious, that policy tends to get replicated by its neighbors, provided there is not federal interference that alters the incentives that state policymakers face or that somehow gets in the way of their ability to do so. And that's something that we should definitely want, because again, it matters. The details of how we regulate business, the details of how we regulate or don't regulate economic activity matters quite a bit. Now, as Judge Riedler mentioned, one area where we're seeing a tremendous amount of discovery and experimentation right now is in the area of drug regulation, marijuana in particular. There's a growing belief, if you believe the polls, that a majority of Americans believe that the way we've approached marijuana policy is not the ideal way to do it, that there should be greater freedom for individuals to use marijuana products, at least in certain circumstances, and for companies to meet that demand, at least in some circumstances. As of today, a majority of states allow some use of marijuana for medicinal purposes. 10 states in the District of Columbia allow some use of marijuana for recreational purposes. What's really interesting when you look at the marijuana policy landscape is, it's not a binary choice. It's not even a choice between criminalization, legalization for marijuana, and pure legalization. Those states that have criminalized, some have decriminalized, so they enforce marijuana laws with civil penalties as opposed to criminal sanctions, at least for low-level possession, things that aren't associated with trafficking. Some states have decided to allow for medicinal use, but have different rules about what qualifies as medicinal use, what sort of showing you need to make, what sorts of prescription you need. The states that are allowing marijuana for recreational use, some allow individuals to produce their own, some allow the commercial sale and commercialization. Even those that allow businesses to operate are making different choices about whether or not it's a business that needs to be licensed, whether there's a limited number of companies that can engage in the business, what sorts of locational choices can be made about where such businesses operate, what they can do to promote or not promote their products, and so on. And these differences matter. The texture of the legal regime that governs this admittedly controversial experiment that's going on in many states matters, and we're learning a tremendous amount from the fact that Colorado's done it one way, Washington's doing it a different way, Michigan's doing it a different way, and that some states aren't doing it at all. So we're actually able to see whether or not these changes, in fact, fulfill the hopes and expectations of the people that are pushing these reforms. And so whatever the end result of this process will be, marijuana policy is a general matter, and including especially the economic aspects of it, over time should be better because we will be able to make policy choices more informed by the experiments that different states have undergone. Now, one of the problems, though, in here, and in a wide range of areas, I mean, again, marijuana is an issue that there's a lot of attention to, and I have a forthcoming edited volume that talks about marijuana and federalism, but we could be talking about regulation of energy development and the similar experiments we've seen with regulation of hydraulic fracturing and how different states have done different things. We could talk about how different states have adopted different approaches to energy use generally and greenhouse gases. Different states have adopted different regulations with regard to vaping. Different states have adopted different regulations to occupational licensing and so on. And these experiments, again, generate information. And for those of us that believe economic liberty is important to human flourishing, should welcome this and welcome the experimental aspect of it because it allows us to generate the information that, if we are correct about our belief in the importance of economic liberty, should provide practical evidence of that for our fellow citizens. A persistent problem, though, is that federal law often impedes the competitive aspects of this dynamic. It dampens the discovery mechanism. Sometimes this is a result of people in Washington, D.C. assuming that anything that is a policy problem must therefore be a national policy problem, forgetting that the federal government is a government of limited and enumerated powers. Sometimes it's because states decide that they don't like having to compete with other jurisdictions, don't like the fact that there is another state that might be offering more economic liberty than it is, and as a result, investors and taxpayers may be moving to that jurisdiction. It's not a surprise that California so often tries to raise the federal regulatory floor to approach the rules that California has decided to adopt, because California doesn't like the economic consequences of losing businesses and losing individuals that don't want to live under those burdens. And so in the marijuana area, for example, just in terms of how the federal government can inhibit the sort of experimentation we like, under federal law, possession, use, and distribution of marijuana is still illegal. And while the federal government, as a general matter, doesn't enforce that prohibition on the average individual that wants to use or even sell marijuana, the fact of federal prohibition has significant effects, particularly on the economic aspects of this industry. It has implications for banking services, because banks can't certify that they are not facilitating illegal activity because of the federal prohibition of marijuana. So it means that marijuana businesses in most states are cash-only businesses that can't provide credit card services, that can't have banking services, and that affects the way that industry operates. It has implications in tax law, because the federal prohibition means a business can't write down its business expenses like other businesses because it's for the purposes of an illegal enterprise. Has businesses for the legal profession, because as those of you that have taken professional responsibility know, you cannot counsel a client to help them engage in prospective illegal activity. It's okay when the client comes to you and says, I did something that was illegal, help me. The client can't come to you and say, create an LLC for me for this business I want. Well, what's the business? Well, I'm gonna sell baked goods. Oh, what kind of baked goods? Well, most, under our traditional understanding of rules of professional responsibility, you cannot do that basic business, provide that basic legal service to that client. Now, some states have tried to modify their rules of professional responsibility to deal with this. So in this case, the fact of the federal government's unwillingness thus far to truly allow states to experiment, truly allow states to be laboratories of democracy, affects the sorts of choices that states can make, and in some ways makes it more likely that some of those experiments will fail, because among other things, it says to those in the industry, you can't use banks, you can't have ethical lawyers represent you, and you have to lie on your tax returns. That's probably not the incentives we want to give to entrepreneurs. That's probably not likely to encourage the most ethical and responsible folks to enter into that industry. We could talk about lots of other examples of the same sort of thing. In the environmental context, federal law that prevents states from trying different ways of maximizing our ability to reduce air and water pollution while not imposing economic activity. We could talk about vaping regulation, where the FDA seems to want to prevent states from adopting different policies with regard to electronic cigarettes that not only have economic consequences, but have public health consequences. Because the best evidence suggests that electronic cigarettes and their proliferation has discouraged a large number of people, including a large number of youth, from smoking, which, whatever the dangers of electronic cigarettes are, they are clearly less than those of combustible cigarettes. So in terms of if we want to take the full advantage of our federalist structure for promoting economic liberty, what I want to close with is that we have to be very attentive to the fact that where federal law operates, it can dampen and restrain the underlying competitive dynamic, which is an important force in both demonstrating the benefits of economic liberty, but also helping us discover and learn how best to promote economic liberty and how best to have the texture of laws and institutions that allow economic liberty to operate while not compromising other goals. If federalism is going to advance economic liberty, we have to allow federalism to operate. Thank you.
And the last member of our roundtable, General Brnovich, is going to talk about Arizona's embrace of economic freedom through programs that include the Arizona Regulatory Sandbox.
Thank you very much, Your Honor. I really appreciate everyone being here. I will say that as I was sitting down at the end of the table there, I couldn't help but think to myself that I am the last speaker on the last day of the conference, on the last panel. So at this point, I feel a little bit like Larry Fortensky. I don't know, well, someone knows who Larry Fortensky is. Most of you may not know who Larry Fortensky is, but that was Elizabeth Taylor's 7th and last husband. And on his wedding night, I'm sure he said to himself, at this point, everything's been said and done that I can do. So there is a side of me that would like to just sit down and say, I agree, and go sit down, but I will not do that. The other thing is, as I was sitting there, I thought to myself, I'm really honored to be on such a distinguished panel. Obviously, or not, maybe not obviously, Justice Bullock and I have known each other for a long time. We're dear friends. And one of the things that, although he did mention, is that I was a research assistant for Professor Bernard Segan, who was one of the 8 people that was in agreement with you. And so I guess that's one lesson you can take away from everything you hear today, that it really, truly is a small world. And you never know how all these interconnections are going to meet up or not meet up in the future. The other thing is I heard the judge do that long introduction for me. I couldn't help but think of when I had the opportunity to introduce Justice Scalia at an event. And as you know, Justice Scalia was not only a brilliant person, but he'd worked in the private sector, he had worked in academia, he had written law review articles, books, and was on the U.S. Supreme Court. And so when I was introducing him, I said, Justice Scalia, how would you like me to introduce you? And he said, Mark. That's a bad Justice Scalia imitation, but you get the point. He said, Mark, he goes, have you ever heard the President of the United States announced or introduced? And I said, yeah. And he goes, how does he do it? And I was like, I don't know. He goes, all they say is, here he is, the President of the United States. So when you introduce me, all you got to say is, here he is, Justice Scalia. That's the only introduction I need. And he goes, I'm going to tell you something. The more important your job, the shorter the introduction. So I'm not sure, you gave me like a 2-paragraph introduction there, so I'm not sure what that means, but if I want to know how important my job is, all I got to do is go home, since I'm married to the Honorable Susan Brnovich, or as we call her at home, Your Honor. Yeah. Anyway, I'm very fortunate to have, I'm a big believer that personnel is policy. And in our office, we've been able to hire some of the best and brightest minds. Some of them are in the audience here today to work for the people of Arizona in our Attorney General's office. And with that comes a lot of creativity, a lot of great arguments, and a lot of great legal skills that are brought to the table. And one of the things that I know there's several folks in our office here that will tell you is there's a lot of Bernoisms. There's things that sometimes, well, it wasn't that funny. No, but that's, no, but thank you. That was not a plant, everybody. No, but one of our Bernoisms is that the fastest way to kill a big dream is to share your idea with a small-minded person. And the second fastest way is to require government regulation or licensure. Because one of the things that we have seen, especially over the last 50 years or so, and some of the other speakers have touched on this, we've gone from a point in our country, let's say in the 1950s, where about 5% of occupations required some sort of license, to now the statistics show about 25 to 30% of all occupations require a license. And I ask you rhetorically, has the world really got that much dangerous? I mean, in a place like Arizona, where it takes 10 times as long to be the licensing between being an EMT and it's 10 times longer to be a cosmetologist? I mean, is that based on any sort of rational basis? So very often we hear policymakers talk about these issues, but really the fact is that they do very little because of all the rent seeking and all the powerful interest and what they have to say. But one of the things that we can do, especially as leaders, is when you identify areas where there can be innovation, to push the ideas and push the legislature to act on them. And one of the things that we did this last legislative session is we took a look at what was going on in the fintech industry, the financial technology industry, and we said this is an area where something needed to be done. While the United States leads the world, is one of the world leaders when it comes to venture capital investment, we actually lag behind when it comes to fintech capital. If you look around the world, there's more than 15 countries now that have these fintech regulatory sandbox where they reduce the regulations and the burdens associated with testing financial technology. Right now in the United States, until Arizona passed a law last year, there was not one single state in this country that provided a regulatory sandbox. So while countries in the world like Great Britain and in countries in the Middle East and even Mexico were creating regulatory sandbox to encourage financial investment, the United States was doing nothing. So working with the legislature, our office was able to pass the first regulatory fintech sandbox in the country. I'm very proud of the work our office did, and as a result of that, we already have numerous applications, and we have 4 companies that are ready to start innovating here in Arizona by providing everything from financial services, microloans, to helping people keep track of payments, to also making it easier for people to pay with electronic devices. Now, obviously, doing or being part of the FinTech Sandbox doesn't mean you get to do everything you want. But what it does mean is you don't have to go through the regulatory burdens or going through the Department of Financial Institutions, the equivalent of the Department of Banking, in order to do business. You just have to apply with the Attorney General's office and make sure that you have a viable business plan, and then you can go to work in providing or your technology or trying to innovate. Now, Arizona is a fintech proving ground, but one of the things that even here in Arizona we realize is that this is something we can't do alone. And this is all tied back into federalism, because we've actually asked for 4 separate federal agencies for their permission to stand down or get out of the way in order to provide more innovation for these fintech companies. So the SEC, the Department of the Treasury, the Consumer Financial Protection Bureau, and the FTC, we're all waiting, we're months later, we're still waiting answers from those alphabet soup of federal agencies to ask their permission in order to deregulate or stand out of the way while we allow innovation in the technology industry. I mean, obviously, technology is changing the way the world works, the way we think. And the private sector can't keep up with the innovations that are going on. What chance do government bureaucrats have? So I think it's very, very important to keep in mind, 2 things maybe to take away from this conference and your thoughts today. One is the states always remember the states created the federal government. The federal government did not create the states. And the framers understood, and they wanted, we always hear about the tension between the legislative, the executive, and the judicial branch. But they also expected, and if you read their writings, their speeches, that there would be a tension between the states and the federal governments, that the states would zealously guard the rights of individuals living in the states and their powers and push back against federal overreach. The other thing that's so important is the rule of law has to mean something. As the judge said in his remarks, my family, fled communism. And I think when you have lived history, not just read about it, you gain a great perspective for how unique and important freedom is and how liberty is a fragile thing. And if you look at the Constitution of the former Soviet Union, it guaranteed all sorts of rights and privileges, but they meant nothing. They were words on paper. Venezuela was one of the most prosperous countries in South America until a dictator named Hugo Chavez showed up and tore up statutes, arbitrarily seized property, denied people the ability to earn a livelihood. And now it's an economic basket case on the brink of civil war. So, as we sit there today and we think about this, as I was also sitting there at the end of the table, I saw just last night a study that said millennials now have a more favorable opinion of socialism than they do of capitalism. And we often hear in academia or in other organizations that, maybe this is a problem of education. Maybe it's a problem of the way these kids are growing up. Maybe it's a result of the fact that in 2008, they lived through the market crash. Well, I would submit to you, it's a problem of not understanding federalism and the rule of law, because they did. They grew up in an age where they saw when the market crashed, what happened. Although people were losing their houses in middle America, the banks were too big to fail. The people at the big brokerage houses, they made off okay. They also see what happens when companies and private individuals that are politically connected, that are powerful, engage in rent seeking, engage in where the government starts engaging in picking winners and losers in the marketplace, favoring one group or one individual over others because of their position or their political campaign contributions. And if you see that going on in the last decade, you can't help but think to yourself, my goodness, capitalism really has failed. But that's not because capitalism isn't working. It's because we've lost our sense of the rule of law, and we've lost our sense of this balance, of this federalism between the states and the federal government. So I hope as you leave here today, and no matter where you work, whether you work for the government, whether you work in the private sector, you appreciate that no case is ever worth your reputation, And no case should ever be worth jeopardizing the rule of law or our system of government or this federalist system that really made this country the great country that it is today. So thank you very much.
So we'd love to take your questions. Before we do that, maybe we'll give each panelist a few minutes to respond to something they heard from other panelists that was of interest. Professor Ides, you want to start us
I
off?
just want to talk with Judge Bollock about the slaughterhouse cases, because I also think that those cases were wrongly decided, and so I'll join your group of 8.
It's a little bit bigger now, and fortunately includes U.S. Supreme Court justices. So I think we're in exceedingly good shape, in large part because of that early groundwork that was laid by Professor Epstein, Professor Segan, who the Attorney General mentioned, and Milton Friedman, and some of the other pioneers.
That's all I have.
I guess the only thing I would add is it does matter. General Brnovich was talking about how Arizona is actually approving businesses through this fintech sandbox idea, and you need to have at least some buy-in by regulators to make this work. So, for example, Chicago passed an emerging business license, the idea of which was supposed to be that all kinds of innovative businesses could get this license. They would have it for 2 years, and in those 2 years, Chicago would figure out how to do the actual regulations for this business. And it just didn't work very well. It's still there. It took them several years before they granted any permits at all, emerging business licenses, because the regulators didn't want to do it. And I think finally the mayor just forced them to grant a couple. There are a few, but during the 2 years, they don't pass any regulations that make it possible then for them to operate. So you've got to have some either constitutional or at least political backing to get these kinds of reforms to work.
Can I, oh, sorry, Professor, can I just say something just 'cause right on top of that? Yeah, I agree with you, and that's one of the reasons why what we did with the sandbox, we actually took it out of the Department of Financial Institutions and so the bank regulators, because we were concerned about that issue, because I used to be the director of the Department of Gaming, and one thing you realize, there are a lot of great people in the public sector and government service, but there are also people there that have a certain mentality of they want to justify their existence, and if they've done one thing one way and no one got fired or nothing bad happened, they want to continue to do that. There's a disincentive to innovate. And so when we were going through the legislative process of this bill, a lot of people, some people were saying, oh my goodness, what's going to happen? We need these experts in the banking industry to regulate this. What do you guys know at the Attorney General's about banking? And my response always was, I can't believe a crook or a con artist would give us their financial information and try to use or go through the Attorney General's office in order to rip people off. That would be the stupidest business plan in the world. Quite frankly, I mean, as you've all heard about with rent seeking and everything else that's gone on, I think it actually is more likely something would happen if they were going through the traditional organizations that granted licenses or privileges to companies doing business. And so, yes, I think to provide a level of comfort, you need to have some sort of oversight, and that's why with our fintech, when we look at what was happening or what was being proposed, we thought that the way to go was to have it in our office, even though, you know, maybe intellectually some people may say that why is the Attorney General's office now granting licenses to people in the fintech sector?
I'll just make 2 really quick points. One, I think that's a really good example of kind of how the texture of regulatory activity or licensing activity matters, right? Once it's been done, we can understand how the choices of which government agencies are responsible for which problems and what incentives the individuals in those agencies face is going to affect how those agencies behave. And so we want different jurisdictions to try different things because, right, you could make an argument why experts with great expertise in the financial sector should be the people making this choice. You can also make an argument that the incentives the people in that sort of agency are going to face in terms of thinking about the traditional business models they're regulating, might actually make them unsympathetic to new business models or new ways of working in that sector. And so they might not be sufficiently permissive. And having different jurisdictions try it different ways is a way that we can learn from that. The other point I just want to make really, really quickly is I do think, as important as it is that we have judges that appreciate the importance of economic liberty and recognize arbitrary government regulation when they see it, we shouldn't fall into the trap of thinking that that's really the silver bullet that solves this problem. Because as we heard from Professor Ides earlier about Lochner, there are lots of areas where we may see regulation that is arbitrary, but that can be justified plausibly on health, safety, or environmental grounds. And if we really want to have as little government regulation as we need to ensure that people and their property are protected, we can't just simply say, well, so long as that's all the government's doing, it's okay. We need to have institutional structures, and I think we need things like federalism that allow us to learn that a lot of regulations that we can theoretically or plausibly justify as protections for public health or for protections of people and their property or protections of the environment, in fact, aren't that necessary or may not, in fact, produce the benefits. I mean, hydraulic fracturing is a great example where, because different states had different rules and because the federal government was thankfully slow to get into that business, we learned that a lot of the plausible stories we were told about all the terrible things that could happen when you try and engage in oil and gas development in that way, in fact, didn't happen. That as soon as companies learned that they might be causing problems that they would be held liable for, relatively low impact and unintrusive rules that merely ensured that we knew who was doing what, so that if a mistake happened, we could go after them, actually did far more than the sort of prescriptive regulatory regimes that our well-intentioned, very intelligent federal environmental regulators usually think is the solution to every problem. And we needed that experience to be able to show that, in fact, a better way to get the economic benefits of this development and protect the environmental concerns that matter to us was actually a less intrusive regulatory regime. So that was just something else that we need to keep in mind.
One quick comment on something that Attorney General Brnovich said. He mentioned that the last time that Justice Scalia came to Phoenix, he had the opportunity to introduce him. And after he gave him precisely the introduction that he requested, Justice Scalia returned the favor by getting up and saying, "What is this name? Brnovich? Said, "Why don't you get an American name like Scalia?"
Clint and I will be appearing at the dinner show later tonight, so
Yes, thank you.
I'd like to comment on Professor Adler's comment. I think you're absolutely right. I think the courts have a role to play here, but they have to be, by the nature of their position, they have to be deferential. And so there will be times when that experimentation, that active experimentation, is the key to determining whether a law or an approach is arbitrary. And I completely agree with you that the states should be experimenting, trying different things, and let's see what works. And I believe, Judge Bollock, you talked about this with the state constitutions as well. I think that's right. I think that the real key to federalism is people actively trying different things to see what works in a world that's changing super rapidly. And like my big fear is AI. It's going to have a huge effect on everyone out there's careers. And the states have to be able to try different things.
Maybe I can pick up on the state constitutional law issues that pretty much everyone has spoken about. We've identified some examples of instances where state constitutions have been interpreted in ways to help enhance and preserve economic liberty. We talked about Judge Willett's decision in Patel. I mentioned when I introduced Ms. Berliner, her success after Kelo in preserving property rights through state constitutional provisions when that effort was unsuccessful at the Supreme Court, U.S. Supreme Court. But are there, does anyone have examples of state constitutional provisions, maybe that touch more than, that are in more than one state's constitution, that are being interpreted ways that are inhibiting economic freedom and economic liberty? Are there provisions out there that maybe we don't have in a parallel in the U.S. Constitution that we have in our state constitutions that have been interpreted to be particularly problematic for certain means of economic development or economic liberty in the states?
So there are a few states that actually explicitly allow monopoly, and that, of course, is not helpful. And I think some of the Western states have things specifically to benefit, like mineral development or oil and gas, that then get used to overregulate competitors or overregulate anyone else. I mean, there's also judicial decisions, like Wisconsin had a very interesting, like 5-part rational basis type test, which they just got rid of. Maybe because it was too hard, but they are now closer, at least, not completely, but closer to the federal. In the wake of Kelo, New York is actually worse than the US Constitution. I don't know how they've done it, but they have. Like, they don't even give lip service to the idea that there needs to be a public use, or you can't take from A and give to B. It's worse. So I'm not aware of a lot of textual provisions that are problematic, except the ones about specific industries, but there could be some.
I would just add, in Arizona, and I'll tee this up for you. Well, you're an old friend of mine, so I'll call you what you like me to call you, Justice Bullock. Tee this up for Justice Bullock. Article 9, Section 7 of the Arizona Constitution is the gift clause, and Justice Bullock at that time was a litigator, litigated a case here dealing with the practice of municipalities of basically subsidizing development, basically picking winners and losers in the marketplace. And so, I mean, I think that's one of those issues where, in fact, we actually, and I don't want to get into this right now, ASU's a great host, but we actually have litigation against Arizona State University right now over its practice of basically renting out its tax-exempt status to major, international corporations to build hotels and other things. And so this notion that in state constitutions, especially the Western states, where when they evolved later, where you had all these problems with the railroads, the canals, cities going bankrupt over this, these bad investments that were being made, they put in gift clauses prohibiting basically those government resources from subsidizing or owning corporations or private stock. And so maybe Justice Bullock, you can talk a little bit about that area in your litigation, successful litigation in the City North.
Well, in the, thank you, Attorney General,
Yes, as I like to be called, yes.
I can't call him general, though, because that makes me feel like I have to salute him, but.
We can work on that.
Okay. Yeah, the City North litigation, a lot of these gift clauses were largely moribund. And at the Goldwater Institute, we challenged a subsidy of a local shopping mall called City North. Basically, there was a huge war going on between cities over sales tax revenue. And a number of retail developers took advantage of that by saying, hey, we'll locate on whichever side of the border is willing to subsidize us more. And so Phoenix elected to provide a $100 million subsidy to a shopping mall developer. We brought that to the Arizona Supreme Court, which ruled that if financial payments are made to an entity under the gift clause, there has to be a rough proportionality in terms of tangible benefit, not, wow, we'll grow the economy and all sorts of indirect benefits, but actual tangible quid pro quo returns. And so that has really, to a significant extent, arrested subsidies of corporations here in Arizona.
and yet hasn't hindered growth, economic growth.
I think Governor Ducey will tell us tonight that there's been substantial economic growth. If he doesn't, I'd be shocked.
Did you have a question, or are you just standing next? Okay. You must be intimidating everyone from approaching, but that one is open. Is there a question over here? Great.
Thank you all for a great panel and finishing out just a fantastic day. I wanted to tag off of something that the Attorney General said, and I'm not sure if this may be too big of a topic for the remaining time, but I do think you hit the nail on the head when you talked about the millennial generation really favoring regulation because we were the first to really get hit with the financial crisis. I was class of 2008. I'm just now going to law school because of the turmoil and just having to work. There was no choice to do anything else. And I'm curious what we can do to improve the trust in the rule of law in states and on the federal level. What can we do to restore that? Because, yeah, most of the people in my classes were very upset that our families were losing their homes and the bankers were getting bailed out with billions.
I appreciate the question. Let me ask you this. Are you a registered Arizona voter?
Kansas.
Oh, well, I don't really care then. No, I'm just kidding.
Well, thank you very much, then.
Just kidding. No, in all sincerity. The really is, it's twofold at least, and you're right, this is a complicated question, but one is partly what the Federalist Society is doing is making sure that we have judges that understand what the rule of law means and are willing to enforce the rights that are provided all of us in the Constitution, which sometimes mean going against what the majority wants. And in fact, we didn't plan this, but I'm going to throw Justice Bullock another softball here that he wrote a book about the case for judicial activism. And sometimes judicial activism gets a very, very bad name, but the reality is we want our judges to be there to protect the rights, especially of minorities. And so making sure we get the right people on the bench is important. Secondly, I think it's important to have the right people in elected office. Very often, what happens is people that are well-connected or, that have, hire lobbyists and stuff, they end up getting access and they sometimes get favors that, other people aren't entitled to. And so I think it's important that to have elected officials or have attorneys general that understand that their role is to enforce the rule of law. And that's why at least in our office, we've done things like, Theranos, there's an HBO movie on next week. There was a story on last night's 2020. Arizona was one of the states that successfully sued Theranos. And Theranos was a company that, had a big rollout here, and there was a lot of people, elected officials, that were tripping over themselves saying how great they were. But we had to hold them accountable for their misrepresentations and the fact that they were lying about what they were capable of doing. It also means that sometimes you have to take on powerful entities. For example, as I said, we've sued, and I grew up a Sun Devil. I love ASU. I went to undergraduate here, and we've got 2 lawsuits against the state universities now. And that's created a lot of pushback, and it makes you very, very unpopular. But as I said, everyone has to be accountable to the law. The rule of law should be, no one gets any extra favors, but no one's disfavored. No one gets an undue bonus, but no one gets an undue burden. And so it doesn't matter who the person is or who the entity is, you have to have people that hold them accountable or elect people that will hold them accountable.
Looks like you've made some friends.
No. I think it is certainly true that we have a younger generation now that has seen some of the worst aspects of crony capitalism combined with governments that are unwilling or unable to let people be responsible for their own economic decisions. And we've let people think that that's capitalism. And that's a problem. And it's a younger generation that unless they're paying attention to what's going on in places like Venezuela, doesn't actually have much knowledge of what it really means to live in a society without significant economic liberty. To me, I think that reinforces the case for letting people see the differences that result when different jurisdictions make different choices. But that doesn't merely involve letting states make different choices. It also means preventing states from exporting the negative consequences of their choices, right? If California adopts crazy energy policies and is allowed to impose the costs of those policies on its neighbors, then we don't get the real experiment, and we don't let people actually see what the consequences are of particular policy choices. So one of the things that's important for the federal government to do is not bail states out when they make bad choices, not federalize those bad choices, but also maintain rules that ensure that when states make good choices, they are able to reap the benefits of that. When they make bad choices, they bear the consequences of that. And I'm fairly confident that under that set of rules, the case for greater economic liberty, greater reliance on capitalism in our policies is going to outperform the alternative every time. But that overall institutional structure has to be in place and has to be respected and enforced.
And one caveat, because you mentioned California, we are an equal opportunity litigator. We just sued California, the state of California, filed an action in the U.S. Supreme Court over their tax policy. So we can help that too.
Great, good.
Looks like we're out of time.
Thank you all for coming. My name is Randall Nice. I attend Arizona's other and better law school. Panelists have talked a lot about professional licensings and requirements. Have any of you considered that maybe paring those back might have the opposite effect you intend, in that when I get a professional license, it represents to potential customers that I have some level of competency in my field and that they can kind of trust me in hiring me. And if we don't have that anymore, basically you're restricting what individuals can, it's harder to go start your own business or start your own company, and you're pretty much stuck having to get started with a already established entity. So is there any consideration that maybe reducing the licensing requirements might have the opposite effect they intend?
No, because what happens when you don't have government licensing is you have all kinds of private mechanisms for indicating who is skilled and who is not skilled. I mean, for example, car repair places, that's not a government license. They all get certified by, I can't remember the name of it.
ASE.
Yeah, they all, I think so. They all get certified by a private group. They go to classes, demonstrate their skills, and if they pass, then they can put up a little sign saying that they are certified, and that exists in all kinds of different occupations before they manage to get regulation passed. So I think in the absence of licensing laws, you will have all kinds of different screens. There will be certification, but there will also be, now with the prevalence of the internet, there will probably be aggregations of consumer ratings. There will be lots of different ways that people will be able to determine the skill level of the service providers they're using.
Just one example of that, when I travel, and even sometimes here in Phoenix, and I'm looking for a restaurant, I go to TripAdvisor and I find an almost perfect correlation between the quality assigned by the rankings and the actual quality of the restaurant. It's just made my life so much more wonderful because I almost never walk into a bad restaurant anymore. Just imagine if we had a government rating service for restaurants.
So I have a question on this. What about state bars?
Definitely unnecessary. Absolutely.
Wait, you may be applauding your own death. If there are, so you may be right, but state bars, if there isn't a state bar, then anyone can practice law, anyone can do a lot of the services lawyers do now. Won't that have an economic effect, a down spiraling effect on your ability to earn a living as a lawyer?
It depends. I mean, for some people
Watch
who
your
are,
applause.
yeah, I mean, for people who are doing very, very low level, like, just real estate documents or filling out forms, yeah, it probably will, because other people can do those and should be doing those. You don't need someone you pay $400 an hour to fill out a form for you. On the other hand, there's still a ton of stuff that non-lawyers really won't understand how to do. I mean, I find just in my daily life, there's stuff I do, and I think, how does anyone manage this who has not been to law school? So I think there's going to be plenty of higher level work, but it is true that some of the lower level work will and should go to lower skilled and lower paid people, in part because that's what everybody can afford. I mean, there's a lot of people that don't get lawyers at all because they can't pay the price for having someone with the level of training that most lawyers have, and they don't need that.
One thing I would just add too is that for a lot of things that we think of where there might be really stringent licensing requirements, brain surgery, there actually aren't, right? You need to be a doctor. Like in most jurisdictions, you just need to be a doctor. But we all don't just go to any regular doctor if brain surgery is something that we think we might need or a family member might need. We actually look at things, it's not quite the TripAdvisor example, but we spend time investigating. And similarly, if you have a complicated legal problem, the mere fact that someone passed the bar isn't really what you're looking for. You want someone that can deal with that complicated legal problem. And so when we are deciding between kind of run-of-the-mill routine services by professionals and things where millions of dollars or life is at stake, that's where we might think there would be a justification for some kind of state certification, and yet that's precisely where we don't see it. And that should tell us something.
Well, if you're all rating this panel afterwards, I hope you give it 5 stars. I thought it was tremendous. I apologize to the folks who want to ask questions. The one rule of judges, you do enforce the time limits. You guys have been a great audience all day, so enjoy the cocktail hour. Please thank our panel. They were terrific.
So great to see you.